Hi, it's Mike DelSignore, a Massachusetts criminal defense lawyer. In today's video, I want to talk about what happens if you're charged with domestic assault and battery, and your case is going to be heard in the Plymouth District Court. Plymouth's a court where I've appeared at for years. I can help you, guide you through the process. First thing you need to know is these cases don't get dismissed on the first court date. A lot of people think that because the alleged victim doesn't want to go forward, that the case is just going to get dismissed. That's not the case. In almost all of these cases, your wife, your girlfriend, family member, typically those people don't want the case prosecuted and want the case dismissed. However, the case will have to be assigned to pretrial and eventually put on for trial. If the government has no other way to prove the case without the alleged victim, the case probably will get dismissed. But there are alternative methods the government has to prove a case, even if the actual victim is not cooperating. There could be a statement from you admitting to the crime. There could be a 911 call where the call comes into evidence under some case law from our United States Supreme Court saying you don't have a right to confront the person. Normally you have a right to confront your accusers, but there's an exception for excited utterances that are considered non-testimonial. That's something you'd litigate, we'd fight, we'd have a hearing over where those statements come in, but that's one option a prosecutor has to prove a case when the alleged victim is not cooperating. There could be a third, an independent witness. If you have an assault and battery and it's in a public place, you're at the casino, you're in a store like Verizon or somewhere with video, the incident might be on video where the government could present the video, the police officer, and argue that even without a victim, they could prove that an assault occurred. So hopefully none of those things will happen in your case, and that we'll move it through the court process. You go through arraignment, pre-trial, put it on for trial, and eventually get the case dismissed. But there is a process. Unfortunately, it does take some time. But I've helped people in courts throughout Massachusetts, Plymouth District Court, courts all over Massachusetts, get through a domestic assault and battery charge. One thing I usually recommend is, if there's no restraining order and you're allowed to go back into the house, you're having contact with the alleged victim, don't talk about the case. Move forward. Maybe do counseling if you need to, but don't talk about the case. Work on yourself, your goals, and show the person that you're moving past this. Address whatever they think the problem is, but don't let the court process seep back into your relationship with the person. You want to keep those things separate. Once at the arraignment, typically you'll be released on your promise to appear if you have a relatively clean record, haven't been arrested before. There could be a request for a restraining order. Generally, the D is going to want to have some contact with the alleged victim to see if they want a no contact order. If they do want one, it's important to have, if they do want contact, it's important to have the alleged victim, and you wouldn't do that, but I would do that as your lawyer, reach out to the DA and let them know that so that the court can enter what's called a no abuse order rather than a no contact order. If the person does not want contact, they'll tell the DA. The court will probably issue a no contact order or a 209A order if they request it. Generally, it's not a great idea to oppose a 209A if the victim wants it, because that's going to inflame them, potentially results in them being more willing to testify. So it's a strategic choice. Typically, it's a smart choice to let them get the 209A. They're probably going to get it anyway. But in some cases, we will oppose them. It's a case by case analysis over whether this is a case that's likely to go to trial. Is this person going to continue to want to prosecute the case, or is this something where maybe they want an order now, but in 2 weeks or 3 weeks their tune's going to change, and that we want to try to keep the peace rather than inflame the situation and try to make it more confrontational. Sometimes these domestic cases involve divorces and other considerations, so want to factor all that in. But in most cases, when you're charged with domestic assault and battery, Case going to be heard in Plymouth. You're going to enter a not guilty plea. We'll move the case through the court process towards a dismissal if they're not on board. If the victim is on board, we'll prepare the case for trial and defend you every step of the way. So call, text anytime, 781-686-5924. My name is Mike DelSignore, and I can help you make the best decisions for yourself when charged with domestic assault and battery.